Let's proceed.
Good morning. May it please the court, my name is Philip Cormier. I'm here on behalf of Cleveland Martin. This case involves the appeal of Mr. Martin's convictions for armed robbery and felony murder, as well as the denial of his new trial motion. A crucial issue in this case was whether or not a robbery occurred, and specifically whether or not any items were taken from Mr. Prevalon's cab that night. The Commonwealth's theory was that Mr. Martin and another individual named J. Sean Robinson had been picked up at the Reservoir Tea Stop around 1:15 a.m., and that they were then taken by Mr. Prevalon in his cab to a St. Elizabeth's Medical Center parking lot. And the Commonwealth's theory was that Mr. Martin, after they arrived in the parking lot, stabbed Mr. Prevalon and then robbed Mr. Prevalon of a black bag and small denomination currency, and thereafter fled to Mr. Martin's girlfriend's apartment in the Jet Court housing complex, which is next to the parking lot. There was no witness in this case who testified that they saw Mr. Prevalon carrying a bag that night or having a bag inside his cab that night.
But there were witnesses who testified about the policy of the cab company to require drivers to have their identification, to have change. There was testimony that someone saw him with a black bag, I think it was a day or two earlier at an event. It was on the ground in front of his feet.
There was testimony by Joe Servius that he saw a bag on the ground outside the Hackney garage prior to Mr. Prevalon's shift. He did not see whether Mr. Prevalon took that bag into the cab or not. There was testimony about Hackney licenses and the requirements concerning those licenses. Mr. Prevalon was found to have his large license. The small license that was supposed to be attached to his person was not found in the cab, but no one testified that they had seen him with that license on his person before he got in the cab. What the Commonwealth did was they presented evidence from a number of cab drivers here about habit evidence. And in particular, they presented evidence that cab drivers had seen Mr. Prevalon in the past with a bag, and that they had also, that they sorted their money in a particular manner, and they described their own personal practices of carrying bags, and they also described, in general, all cab drivers carry bags, 99% of cab drivers carry bags, everybody carries a bag. Now, this relates to both the sufficiency argument and the first part of the ineffectiveness claim. Trial counsel did not object to this line of so-called business habit evidence. In the Commonwealth, evidence of a personal habit is not admissible. The Palinkas case, which I think is the seminal case on business habit evidence, says that that type of evidence is permissible if there's a foundation that shows that there's some sort of routinized conduct allowing one to make an inference that that particular conduct was being followed at the time in question. And in this case, we have a bunch of cab drivers who testified, but none of them described how often they worked, how many times they interacted with Mr. Prevalon, how many times they had, what their interactions were in the past with him. It was very groundless in terms of the foundation.
If I could step you back for a moment, okay? Let us imagine the evidence was that they robbed a cabbie and there was nothing there to rob. Isn't he still guilty of felony murder because it's an attempted robbery?
The Commonwealth never pressed that theory at trial.
What does it mean to press? Did
They never argued it.
Did the judge instruct on it?
The judge did instruct on it.
The judge did?
Yes.
So the jury had that option?
Did have that instruction. It was never argued. It's not been pressed in the Commonwealth's briefs here.
But the evidence is certainly sufficient to show that, I mean, there was no other motive other than robbery, so maybe it was a robbery where there it turned out badly, well, certainly turned out badly for the victim, but maybe there was nothing that they, for whatever reason, they didn't steal what they hoped to steal.
And what I would say, Your Honor, is that that's not the case that was tried here, though. The case that was tried is that there was a black bag, there was small denomination currency, and that those items were taken. No argument whatsoever in the closing about oh, you can convict these guys, convict him if this is an attempt. None.
But why should that matter? I mean, why should, in terms of what is a fair outcome, if your client attempted a robbery and ended up with nothing, why should he get
I
off? But if he
acknowledge
steals
it may be-
a bag or he steals $10, then suddenly he's guilty of felony murder.
I acknowledge that it may be an issue with respect to sufficiency. However, I do not think it's necessarily an impediment to the ineffective assistance claim, which is that, and that's a broader claim here about whether anything was taken.
Okay, and let me turn to that. I know that we have palinkus. Why is evidence of a business habit more probative than evidence of a personal habit? Why is it that I couldn't testify that I brush my teeth every morning, which I do? So when somebody asked me, did you brush your teeth on October 10th, 2007? I can't say I do it every morning. I'm sure I did, and the jury can evaluate that. Unless I say it's part of my business to brush my teeth, that I need to. It's obligatory to come to the SJC and have brushed your teeth. Why does it make any sense?
In part, it stems from the origins of these cases, which started in the business context and focused on routinized business procedures, for instance, mailings, date stamping, that type of thing. And I think that they recognized that in a business context, there may be established procedures that are, followed by a number of people at that business, as opposed to a personal habit of brushing your teeth. I unfortunately didn't brush my teeth last night, but I did this morning.
Good to hear.
Before I came in. So I think that in the business context, there's more reliability associated with the habit than necessarily in the personal context. And the other thing is that the personal context, in terms of what evidence is used to establish the habit, may come from a single individual, whereas in the business context, there may be multiple individuals who can describe what that habit happened to be and whether it was followed or not.
May I ask you a question, back to the black bag? Wasn't there testimony by the defendant's girlfriend that she went down to the cab at his request to retrieve items from the cab?
That's correct, Your Honor. And what happened is after Mr. Martin and Mr. Robinson went to the apartment, Laura Pizarro went back out into the parking lot to the cab to retrieve several items that Mr. Robinson had left in the cab in the back seat. That included a hat, a cell phone case, and I believe a sneaker.
Well, could she have retrieved a black bag as well?
She did not bring a black bag back to the apartment. Mr. Robinson and Mr. Martin, there's no evidence that they went back out to the cab afterwards. In fact, after she returned to the apartment, she announced that she believed that the cab driver was dead. And Mr. Robinson turned to Mr. Martin and said, "Let's go out and rob him." Mr. Martin said no. Well, if they had just robbed him, why would Mr. Robinson be suggesting that they go out and rob him? It doesn't make sense. So she didn't testify that she saw a black bag out there. She didn't testify that she, looked for a black bag. She didn't know about a black bag. The evidence was when they came to the apartment, they didn't have a black bag. She didn't bring a black bag back to the apartment, and no black bag was found in any of the dumpsters or in the apartment or in Mr. Prevalon's home or his personal automobile. The black bag was never found, and the Commonwealth argued that the absence of the black bag is evidence that Mr. Martin must have taken it. And the problem, Your Honor, the other problem with the habit evidence here is we have all of this testimony about the other cab drivers' personal practices of carrying bags or personal practices of sorting their money, where they take smaller bills and put them in the bag and put $20 bills in their pocket. Mr. Prevalon was found with 5 $20 bills in one of his pockets, which suggests that there wasn't a robbery. And
But there was testimony from at least one person that she had arranged for him to pick her up, and she paid him $7, and that was not there. So where was the money?
well, and that's true, and she did testify to that. However, post-trial,
Which would suggest there was a robbery.
that
The
might
money
sug-
was gone.
that might suggest that there was a robbery. However, there was in evidence dispatch tickets and testimony from the cab dispatcher, Mr. Concepcion, that Mr. Prevalon was dispatched to 3 fares in between the time that he picked up Ms. Pastahova and the time that he picked up Mr. Martin. The small change that Ms. Pastahova gave Mr. Prevalon could well have been paid out to these other fares to explain why it was missing. Unfortunately, trial counsel never investigated those dispatch tickets. One prong of the ineffective assistance claim is that he should have done that. Post-trial, we conducted an investigation, and we found one of these individuals, Peace DePiro. Ms. DePiro didn't testify. There's a stipulation in the record about what Ms. DePiro told us in the Commonwealth. And what Ms. DePiro says is that she normally took a cab from 60 Longwood, which is where this dispatch ticket, where the originating address was, to her home in Alston, and that she typically paid approximately $13 for the fare. She said that on some occasions, she may have paid with a $20 bill. Had she done that on that night in between, the $7 that Ms. Pastahova had paid may have been paid out to her. The Commonwealth agrees, and agreed at the new trial motion hearing, that Ms. DePiro was one of those interim fares that was picked up that night. That was and let me just add one point.
So the other 2 were not found.
The other 2 were not found. The other 2 intervening fares were not found.
So it all sort of turns on this one.
That's the only evidence we have, Your Honor.
Right.
At trial, what trial counsel did is that he cross-examined the dispatcher and got the dispatcher to say that Mr. Prevalon could have picked up fares off the street in that intervening time. Unfortunately, there was no evidence that he had picked up anyone. And then in his closing argument, he characterized Ms. Pastahova as the last call that night. That was an erroneous concession, that she was the last person in the cab that night, and therefore the money that she had paid likely would have been the $7 that she had paid for her fare. Had trial counsel conducted an investigation into the dispatch tickets, and had he found Ms. DePiro, he clearly would not have made that erroneous concession that Ms. Pastahova was the last fare. Wouldn't have happened. Now, if I could just get to one other aspect of the ineffective assistance claim, and that's this. There was a video, surveillance video of the St. Elizabeth's parking lot.
Is that available?
That is available, and it's actually, it's in a sleeve in the appendix. I don't
if we
have
have it, we
the
have it.
site off my hand, but all of you have it, and I urge you to look at it. What the video shows is the following. The video shows that the cab coming into the parking lot at approximately 1:20 a.m. The video was shown to the jury between 1:21 a.m. and 1:47 a.m. It shows the cab come into the parking lot. A short while later, the cab ends up resting against a light pole. And thereafter, at approximately 1:46, 1:47 a.m., there's a very pixelated image of a person walking across the parking lot toward the cab, at the rear of the cab, and then walking back toward the direction of Jet Court. That was Laura Pizarro. There is a second segment that occurs at approximately 1:52, between 1:50 and 1:52 a.m. This was not played to the jury, nor was it known, nor was defense counsel aware of this segment. This second segment shows another person walking across from the area of Jet Court to the back of the cab, and then back again,
What time?
approximately between 1:50 and 1:52 a.m.
Was this after?
That's after Ms. Pizarro went out to the cab. Trial counsel sought to elicit from security people at St. Elizabeth's that the cab was, that the parking lot was frequented by people at night, that people hung out there, and all of the security people denied that that was the case. They testified to the opposite, that the parking lot was infrequently visited by people at night, that they did not have a lot of vandalism out there. And Michael Tabik, the head of security, testified that after, that he had viewed the entire video all the way through 6 a.m., and that he did not see anybody else in the parking lot out there after the 1:47 a.m. Segment where Laura Pizarro was out there. Now, had trial counsel seen that segment on the video, it would have been affirmative evidence that a third unknown person was out there. There was no evidence that Mr. Martin and Mr. Robinson went back out there after Ms. Pizarro was there. Trial counsel could have used that evidence.
So how could he have used that?
Well, first of all, he could have played that segment to the jury to show that a third person was out there.
And assuming the third person was there,
It would have suggested that that person may have taken the black bag out of the cab, if there in fact was a black bag.
Let me ask you, I take it that actually the murder then didn't occur in the parking lot? Because I take it,
The murder did occur in the parking lot.
but
inside-
not with it, but so it's videoed?
Well,
You got the
Your Honor,
video?
this is a very pixelated video. You can't see people's faces. What happens is that the video is from one end of the parking lot.
Yeah.
The cab is driving into the parking lot at the other end.
Yeah.
And then ends up against a light pole there. You can tell it's a cab, it has the light on top. You don't see anybody from the time it comes in to the time that it hits the pole, anybody moving anywhere. You do see after that at 1:47 a.m., someone comes in.
So the people that were in the cab that killed the cab driver obviously got out before the cab entered the parking lot?
They got out at the top of the parking lot on the other side of the cab.
Okay.
Can you see this on the video?
You cannot see that on the video because the camera is
Right.
at this end and the cab is coming in on this side. So the video is facing the driver's side of the cab. Mr. Martin testifies that what happens is when they get to the parking lot, a fight erupts between Mr. Robinson, who is behind the driver's seat, and Mr. Prevalon. That Mr. Robinson pulls Mr. Prevalon into the driver's seat, and that Mr. Prevalon is kicking at the door where Mr. Martin is sitting, that he kicks the window out. Mr. Prevalon is found to have glass embedded in his calf, and Mr. Martin's fingerprint is found on the top of the door jamb on the right rear side of the cab, showing that he got out of there on that side. He testified that he got out the broken window. So the video doesn't show that. However, had trial counsel had that, he could have shown that portion to the jury. It wasn't shown to the jury. He could have used it to cross-examine Mr. Tabik. The entire video through 6 a.m. was not preserved. There was only a short bit beyond that was preserved, but Mr. Tabik testified, I saw this whole thing, and there was no one else was in the parking lot that night, therefore no one else could, the conclusion is no one else could have gone to the cab that night to take this bag. It was powerful evidence. Trial counsel missed it. And I think that it would have made a difference. It would have provided defense that he didn't otherwise have. The same thing with the dispatch tickets. If the dispatch tickets had been effectively utilized, if they had been investigated, Mr. Martin actually wrote to trial counsel and asked him to investigate the dispatch tickets. And trial counsel says, I can't recall having investigated them. His investigator doesn't recall investigating the dispatch tickets. They would have found piece de Piro. And that could have accounted for the missing small denomination currency in this case. Now, if I may, I would like to just address several other issues here.
well, you have 30 seconds.
First of all, with respect to the McNulty, Mavrodakis, and the Rivera issue, this case is materially different. The police in this case did not identify or provide the name of Mr. Martin's lawyer when they met with him. And secondly, the letter was not merely a directive to the police not to speak to his client. In that letter, if I have 30 seconds, Your Honor, Mr. Joya says, I want to talk to Mr. Martin before the police do.
Did Mr. Joya know that Martin was incarcerated in Virginia?
He knew that he was incarcerated in Virginia, yes. He did not know the police were interviewing Mr. Martin. But he did say that he wanted to interview him. Both McNulty and Rivera identify that type of fact as a core fact that's necessary to actualize somebody's Miranda rights, and that was not communicated. The typewritten note at the top of the Miranda warning did not communicate that fact. Thank you.
Thank you, Counsel.
Yes, ma'am.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. With me today is Assistant District Attorney Patrick Hagan, who is the trial prosecutor in this case. We ask the court today to affirm the defendant's conviction for the first-degree murder of Hero Prevalon. Now, my brother spent about 19 and a half minutes speaking about 4 pieces of evidence: the black bag, small change, the dispatch tickets, and the surveillance tape. I don't want the court to be misled to think that that was the only evidence that the Commonwealth presented about the fact that the defendant in this case robbed and murdered the victim, because it wasn't. The Commonwealth presented affirmative evidence that the defendant in this instance robbed the victim. Most specifically, we presented the defendant's statement in which he said, "I killed a cab driver during a robbery gone bad." But even more than that, Chief Justice Ireland, you asked about a testimony about a black bag. It was, in fact, a black bag that Joseph Cerveris saw that evening that was at the defendant's feet. But even more so than that, it wasn't just that it was at the defendant's feet. The Commonwealth also presented evidence that they searched for the black bag in the cab, and it wasn't in the cab. They searched for the black bag at the defendant's home. It wasn't at the home. There was evidence that the black bag was never found at that Hackney garage where Joseph Cerveris made that observation. So the reasonable inference from from all that evidence is that the victim did indeed have a black bag that evening, and he didn't have the black bag when he was found by the police at 6 o'clock the next morning.
Who testified to Mr. Martin's statements?
It was Vernon Petway, who was, admittedly, while he was a jailhouse informant, his credibility was for the jury to decide, and the jury certainly had impeachment evidence and the fact that he was an informant in front of them. So
Is he the only
acknowledging that.
informant that testified?
No, there was another informant that testified as well. His name was Robert Taylor. He didn't provide any evidence about specifically the robbery, but he did provide evidence about the murder, which was cumulative of other evidence. Specifically, Robert Taylor testified that Jayshon Robinson, who was the co-defendant in this case, however, he was tried differently, Jayshon Robinson held the victim around the neck while the defendant, in this case, Cleveland Martin, stabbed him. That evidence was corroborated by Stephanie Rodriguez, who testified as to the same type of information at trial. Laura Pisano testified as well that the defendant told her that when he stabbed somebody, and when he stabbed somebody, the knife slid in easily. That's also corroborated by the medical examiner in this case, who testified that the place where the victim was stabbed was in between 2 of his ribs. So indeed, there wouldn't be much resistance that was felt when the knife did indeed go in.
Assume for the moment you're wrong. Assume for the moment the evidence is not sufficient, that there indeed was anything taken.
Sure.
Does it matter?
No, it doesn't in this case. The jury did find the defendant guilty of armed robbery. A guilty was placed on file. Of course, that would need to be vacated. However, the attempted commission of a robbery is sufficient to support a charge of felony murder. This court affirmed that just this year in Commonwealth. I don't have the site in front of me, but just this year, it's a 2013 case that this court affirmed that indeed was true.
And the jury instructions said that that would be enough for felony murder?
Yes, the jury instructions specifically did. I would point the court to volume 12, pages 143 through 144. That's where the judge specifically told them that they could find if he attempted the commission of the crime, it would be enough. She did lay out specifically the elements for intent as well, which she said that they had to find that the defendant had the specific intent to rob and that he took some act in furtherance of that act.
And I assume we'd have to get rid of the robbery anyway if we affirmed on felony murder.
Yes,
So that would not survive regardless.
it would not survive regardless, yes. Turning, however, to the business habit evidence, Justice Gantz, you asked a question about why we don't allow personal evidence in. And in preparing for argument today, it seems that the origin can trace back to an 1893 case from this court, Commonwealth v. Nagel. And in Nagel, this court says the purpose of proving that one has or has not done a particular act is not competence to show that he has or has not been in the habit of doing other similar acts. And they give the specific example that if someone is known to be drunk, if they're known to have a habit of being a drunkard, it's not enough to provide the habit of a person's drunkenness to show that they were drunk on one particular occasion. And I'd say that the Commonwealth, this is a business, we are asserting that this is a business habit. However, we're not using this habit in the same way. We're not using it to affirmatively show that the defendant did some sort of act. We're not saying the defendant was known to rob people, therefore he robbed someone in this case. We're using it in a very different way. And moreover, there was substantial testimony presented from individuals who knew the victim well, who had worked with the victim over a course of many years. I think looking at the testimony, the person who had known the defendant the least, there were two, Goldie Jolly and Lauren Baptiste. They had known the victim and worked with him every day for 5 years. And the most was obviously his uncle, who had known the victim since he was for 32 years, his entire life. But these were individuals who testified that encountered the victim time and time again in his course of employment. And 5 of these individuals testified that every time they saw the victim, either when he was coming to work, while he was in the cab himself, or while he was leaving from work, he always had this black bag. And specifically, his uncle, Wilbert Prevalon, testified that the victim in this black bag always kept certain things. He kept his street guide, he kept his change, and he kept his small cab driver's license. And those items were not found in the cab that evening, but they provided even more testimony than that. They said that when they saw the victim, they knew that when he worked, he carried both his Bible and a book. And importantly, when the officers searched the cab after the murder occurred, they found his Bible and his book in the dashboard of the cab. So it's not just testimony that it was a habit, and we don't know if he followed the habit on this night. It's testimony that it was a habit. He was known to carry these type of items, and 2 of these items were found in the car.
So what do we make of the fact that the video apparently, or appears to suggest that some third person may have taken these things?
I have 2 arguments to that. The first is the Commonwealth has objected strenuously to the fact that at 1:50 at night, the part of the video that my brother is now asserting there is a person, that the figure is even a person. I've watched this video multiple times, and I argued this at the motion hearing as well. I've watched it time and time again, and I just don't see it. And it is part of the record. It's specifically located on page 775 of the defendant's record appendix, and I urge the court to watch it too. And what I urge the court to do...
Sorry, the video is located at page 775?
Yes, it's a sleeve.
Oh, it's a sleeve.
Yeah, it's a sleeve. But if you're looking for the specific page, that's where it is, Your Honor. And look at 1:50 in this video and compare it to the time of the video where Laura Pizarro is seen to come out, and compare the difference in how it looks when she comes out and how this shadow at that time comes out. And I would assert to the court that it's entirely different.
What do you think the shadow is?
I don't know what the shadow is.
Well, got to be something, right?
It could have been a cat. It could have been a leaf that blew down. It's really, when Your Honor sees it, I don't want to characterize it, but when you see it, you'll understand what I'm saying. And Judge Quinlan didn't believe that it was a person either in her findings. And aside from defendant's characterization, there's nothing to show that it is indeed a person. Noticeably absent from any kind of showing that the defendant made is an affidavit from, let's say, an expert who does video enhancement, who said, I was able to enhance this video and see, look right here, this looks to be a person. There's not that type of evidence here. Moreover, the entire tape itself, while it wasn't played in its entirety to the jury, it was introduced in its entirety as an exhibit, and it went back with the jury to the jury room during their deliberation. So it certainly was available for the jury to look at. But as to my second point onto the surveillance tape, it isn't as if defense counsel didn't make this argument to the jury. He argued to the jury, look at what we have. We know that Laura Pizarro came to this car at 1:47, and we know that St. Elizabeth Security found the victim at 6 o'clock in the morning. And we don't know if anyone came to this car in the meantime. He argued that to the jury. It was before the jury, and it was certainly part of his defense. So my brother hasn't shown what materially would have been gained had this video with this.
Well, I assume if the jurors could draw the inference from that there was something else, some other interaction with the cab that would have reinforced the argument.
While it would have reinforced the argument, this certainly isn't the type of case where that argument simply wasn't made to the jury at all. It was made to the jury. It was strongly made to the jury.
But I take it the head of security then testified that he reviewed the tape and there were no other people.
Yes. Okay. Yes, he did. And he testified the same. He testified that he watched it that morning after the discovery of the cab in the parking lot before the police officers arrived. I'd like to turn now to my brother's brief argument about this statement in Virginia. This case seems to appear the same and be controlled by Commonwealth v. Rivera. And to support that, I just would like to read the text of the actual letter to the court now. It can be found on page 158 of the record appendix. And in this letter, which Attorney Joya wrote to the Suffolk County District Attorney's Office, he specifically said, at least until I've had a sufficient opportunity to speak with Mr. Martin, I ask that no law enforcement personnel attempt to question Mr. Martin in connection with the alleged homicide of Mr. Prevalon. There was no...
Before you go into that, could I just get a few facts to put this in context?
Sure.
The defendant, Hova, and his girlfriend went to Virginia and were apparently arrested on, September 28th, 2005?
Yes.
And what were they arrested for? Was it in connection with this?
Yes.
Okay.
There was a warrant issued, I believe, the day before, September 27th.
All right, and this letter from Attorney Joya to the district attorney was what date? Wasn't it 2 days later?
Yes, September 30th.
All right, so he knew they were in Virginia, but he had no information that the police were going to be going to Virginia to...
The police were going to Virginia to arrest both J. Sean Robinson and Cleveland Martin. That was the purpose of them going down to Virginia. As to Mr. Joya's knowledge,
There was nothing in the record about this.
There's nothing in the record other than when they do get down to Virginia, Cleveland Martin says to them when they say, you have an attorney, he says, good. So it certainly appears that there was never... Cleveland Martin wasn't aware of the fact that he had an attorney.
Was not aware of it.
No, it doesn't seem that Mr. Joya had made any attempts to contact Cleveland Martin or had contacted Cleveland Martin to tell him that it was indeed he was indeed his lawyer. But important to this letter is that this letter is missing any kind of directive language, as this court spoke about in Commonwealth v. Rivera. It doesn't say to anybody, please tell my attorney, please tell my client that I want you to tell my client that I don't want you to speak to. That didn't come out right, but it doesn't contain any kind of that directive language directing the police to tell Mr. Martin anything. Moreover, there's absolutely no requirement in any Massachusetts case law that the police tell the defendant who his specific attorney is. And it's indisputable on this record that they did tell him that he had an attorney, and they did alter the Miranda waiver form, so he was aware of the fact that he had an attorney.
But they didn't tell him that his attorney wanted to talk to him.
No, Your Honor,
And that is what the letter was basically saying, that the lawyer wanted to talk with the client.
no, I'd say the specific language was that the Suffolk County District Attorney's Office was not to speak with his client.
But that he wanted to speak with his client before they interviewed his client. That's what the letter also says.
Yes, but it doesn't say, tell my client that I specifically direct you to tell my client, don't speak until I'm here. I also think a line can be drawn. It's different than, let's say, Mavrodikis, where in the middle of questioning, an attorney calls and asks to speak with his client. That certainly is a different situation than a letter that's just sent to the district attorney's office days before anything happens with no attempt to actually speak to the client. That's an entirely different situation than that's presented here. Moreover, the right of the defendant to invoke his right to counsel, it's the defendant's right. And where he is aware you have an attorney, your attorney wishes to be present during questioning, he could say, you know what, I want to speak with my attorney. But he didn't do that. And he
Was he told that his attorney wants to be present during questioning?
I believe so, yes.
He
I
was
mean,
told
in the
that.
written form.
Yeah, in the written form.
Where it says that, asks that him to acknowledge, I've been advised by the detectives that a lawyer has contacted the Boston police and stated he represents the defendant and he wishes to be present during any questioning. Is that?
Yes, yes. And that was read to the client, and the client was asked to acknowledge that he understood what that meant. They then went through the remainder of the Miranda rights. The defendant did make a certain statement, and it was a very short statement, and then he immediately invoked his right to counsel to not be questioned until his counsel was present. So on the record, it certainly seems that he understood that right and understood that he had a right to stop questioning until his counsel was present. And if the court has no further questions, the Commonwealth would ask that you do not use your power under 33E to reduce the verdict, as there is overwhelming evidence that the defendant in this instance both robbed and murdered the victim. Thank you.
Thank you, counsel. We'll take a brief recess.
All rise.